Hi, I'm Gary DeWitt, attorney at law, and today I want to talk to you about trusts. Why would you want a trust? The number one reason most people state for wanting a trust is to avoid probate, but not a lot of people know that it gives them protection from lawsuits, from creditors, lets them control their assets not only during their lifetime, but later to protect their children. And finally, it gives you protection of assets. If something happens and you can't make decisions about your money, the trust and the next trustee can help you make those decisions. Gives you active management of your assets during incapacity. You can control, you can put strings on the assets even after you're gone. You can name successor trustees to manage the money when you can't. And it gives you somebody to advocate for your finances. What is a trust? A trust is a three-party agreement between the grantor, trustee, and the beneficiaries. The grantor, usually you, puts stuff into the trust. The stuff is to be managed by the trustee, which could possibly be you, and it's for the benefit of the beneficiaries, you, your family, and your loved ones. Now, what a mouthful. That's kind of a legal definition, so let me try to break this down a little bit. What does a trust require? It requires a grantor, a trustee, beneficiaries, an agreement, and the stuff, or as in law, we call it the res. Now, the definition I like to use, it's a bucket. You put stuff into the bucket, and you also put a set of instructions in the bucket for the trustee to follow. You can also lock the lid to the bucket so that nobody else can get the money except under the conditions you specify. Now, during your lifetime for a living trust, a living revocable trust, you get to hold the handle to the bucket and control the assets that are in it. Then when you can't control them anymore, the bucket's handed to somebody else, the successor trustee, to manage the money for the beneficiaries. A revocable living trust is a trust that you create while living. You can revoke it by its very nature, revocable, and you can modify it at any time you want unless you've added instructions to make it non-modifiable. You put the stuff into it, so you're the grantor. You manage the stuff, so you're the trustee. And you and possibly others get the benefit from the stuff, so you are a beneficiary of the trust during your life. What does this mean? You put stuff in at will, you take stuff out at will, you can modify the trust agreement, you can revoke the trust, and you are in full control. When you're going to choose a trustee, you need to do it with care. You need somebody that will carry out the express terms of the trust, defend the trust, properly invest the assets, and be impartial among the beneficiaries. So, for example, if you pick your oldest child, they may try to benefit themselves more than the other children. Maybe you should name a bank or a professional trust manager that will be impartial. A trustee must be loyal, and a trustee may not delegate the responsibility. If they don't want it, they just need to resign as trustee. Now, here is a sample of what a trust can do. Some children moved away from home and got heavily involved in a drug culture. The mother changed her trust to withhold money until the children are clean and sober again. So, the children go to court, challenge mom's decision. Judge rules in favor of mom. They say it's her money, it's her decision. She protected her children from themselves, and it also points out that trusts are solid in